Lincoln and the Constitution, Part 2. Clement Vallandigham was found guilty by the military tribunal that tried him, and he was sentenced to prison for the duration of the war. This outcome generated a public outcry. A bipartisan public outcry. Democrats and even some Republicans condemned Vallandigham's treatment. So Lincoln now got caught in the middle of a controversy, not of his own making. Now, on the one hand, many Americans felt that Vallandigham got exactly what he deserved. And that's Lincoln's Republican base that he cannot afford to alienate. But on the other hand, many Americans felt that Vallandigham had not received justice, that his First Amendment rights had been violated. So what did Lincoln do? Lincoln decided to uphold the guilty verdict of the military tribunal, but to reduce the sentence from imprisonment for the duration of the war to banishment to the Confederacy. And so Vallandigham was taken out of prison, he was brought to Confederate lines, and he was handed over to the Confederates. Here, you guys take him. Vallandigham eventually made his way to Canada. From Canada, he ran for governor of Ohio, but he lost the election in a landslide. Vallandigham later authored the 1864 Democratic Presidential Platform, calling for an end to the war. That platform was repudiated by the 1864 Democratic presidential candidate, George B. McClellan. In the end, Vallandigham died by his own hand in a tragic accident. Vallandigham was a lawyer. He was defending a client accused of murder. Vallandigham was trying to make the argument that his client was innocent because the murder victim murdered himself. He accidentally shot himself. Now, Vallandigham was trying to act this out, and unbeknownst to him, he was acting this out with a loaded pistol, and he pulled the trigger and he literally shot himself to death. This did not happen in the open courtroom. It happened when Vallandigham was rehearsing for the case in his hotel room. I understand that Vallandigham's client was found not guilty in the end. I guess that's going the extra mile for your client. Anyway, to defend his actions in the Vallandigham case, Lincoln did what he always did in these situations. He released a public letter to the newspapers, explaining himself. In the letter, Lincoln made a complicated legal argument. Basically, what Lincoln said is that Vallandigham's speeches in Ohio, those speeches against the war, against the draft, they were so inflammatory, so incendiary, that when Vallandigham made those speeches, it was incumbent upon him, it was his duty, at the same time, to warn and instruct and admonish his audience. Resist the draft, resist the war, but you must always do it legally, constitutionally, through the ballot box on Election Day. And since Vallandigham did not do that, Lincoln felt, I'm going to uphold the verdict and simply reduce the sentence. Of course, the irony here is what? That's exactly what Vallandigham did do when he made his speeches. He did warn and instruct his audience, resist the war, resist the draft, but always do it legally and constitutionally through the ballot box on Election Day. And so Lincoln settled the Vallandigham case on false pretenses. Could Lincoln have been misinformed about the case? Absolutely. This is an age with no video, no sound recordings. What Lincoln knows about the Vallandigham case, he reads in Republican newspapers and hears from his Republican friends. So yes, Lincoln could have been misinformed about the case. Or perhaps, more cynically, perhaps Lincoln simply pretended to be misinformed about the case to wiggle off the hook. Another argument Lincoln made was this: must I shoot the simple-minded soldier boy who deserts, but not the agitator who induces him to desert? That's old-fashioned common sense, right? Must I shoot the simple-minded soldier boy who deserts from the military, but not the agitator, that is, Vallandigham, who induces him to desert? Old-fashioned common sense. But, if you think about it, Lincoln's reasoning violated freedom of speech, violated the First Amendment. The guilty party is the one who deserts from the military, not the one who speaks out legally against the draft. And so really, Lincoln should have shot the soldier boy and left the agitator alone, at least according to the First Amendment. Or better yet, don't shoot the soldier boy, but still leave Vallandigham alone, because he was merely exercising his First Amendment freedoms. One final Lincoln action of dubious constitutionality. Lincoln ignored a federal circuit court order declaring his suspension of the writ of habeas corpus unconstitutional. And who was the federal judge who declared Lincoln's suspension of habeas corpus illegal? It was none other than the Chief Justice of the Supreme Court, Roger B. Taney. Now I need to clarify something. Students often think because the Chief Justice of the Supreme Court handed down this ruling that it is a Supreme Court ruling. It was not. In the 19th century, Supreme Court justices wore two hats. They sat on the Supreme Court, but they also served as lower federal court judges. When Taney issued the ruling declaring Lincoln's suspension of habeas corpus unconstitutional, he did that not in his capacity as Supreme Court justice, but in his capacity as federal circuit court judge for the District of Maryland. So yes, the Chief Justice of the Supreme Court declared Lincoln's suspension of habeas corpus unconstitutional, but it was not a Supreme Court ruling. All right, what does it mean to suspend the writ of habeas corpus? Well, ordinarily, if the government arrests you, what must the government do? It must charge you with a crime and bring you to trial. But if the government suspends habeas corpus, the government does not need to do those things. The government can arrest you and lock you up without charging you or bringing you to trial. In the spring of 1861, President Lincoln suspended the writ of habeas corpus between Washington, D.C. and Philadelphia. He had to do it, or Maryland might secede. Washington, D.C. would be in Confederate territory between Maryland and Virginia. Lincoln would be a prisoner, Congress would be prisoners, the war would be over, and the South would have won. Lincoln had to do it. Now, was it unconstitutional for the president to suspend the writ of habeas corpus? Well, according to the Constitution, who has the power to suspend? Where in the Constitution is the power to suspend the writ of habeas corpus? It's in Article 1, which lists the powers of Congress. But how is that one sentence actually written? It's written in the passive voice. It's unlike all the other powers of Congress, which are written in the active voice. Congress shall have the power to do this. Congress shall have the power to do that. This one sentence is written differently, though. It's written in the passive voice. The privilege of the writ of habeas corpus shall not be suspended, unless, when in cases of rebellion or invasion, the public safety may require it. And so the power to suspend the writ of habeas corpus is in Article 1 with the powers of Congress, but that one sentence is written in the passive voice. For Lincoln, that was an opening. Lincoln's interpretation of this is that the Constitution allows the president also to suspend the writ of habeas corpus, in addition to Congress having the power, at least in certain situations. Lincoln's reasoning was this: what about when Congress is not in session? Surely the founders, when they wrote the Constitution, they did not intend for this vital national security power to go away when Congress is not in session. And so it has to go somewhere. Where does it go? To the president. And so Lincoln's argument, there are certain situations when Congress is not in session that the president has the power to suspend the writ of habeas corpus. Now, by the way, why did the Constitutional Convention put this one sentence in the passive voice? Well, when they were writing the Constitution, they didn't yet know where they were going to put the power to suspend habeas corpus. In Article 1 with the powers of Congress, in Article 2 with the powers of the President, and so initially they wrote the sentence in the passive voice. And then when they decided to put it into Article 1 with the powers of Congress, they never changed it to the active voice. Well, that created this opening for Lincoln.